5 seconds to go. Start. A closer report was filed by the local police, but the judicial magistrate did not accept the same and has directed further investigation in the matter. Learned counsel for the respondents submitted that the real reason behind the dispute between the appellant complainant and his family members and the accused and his family members related to political rivalry, as the appellant complainant had lost the election for the post of village pradhan and then proceeded to falsely implicate the accused persons. Learned counsel argued that where there are two bullet injuries, one each to the two deceased by three assailants, there is a possibility of over implication of the accused persons. Finally, an assurance has sought to be extended to this court that the respondents will not abscond, as they are permanent residents of the village and they shall continue cooperating for timely completion of the trial. Mr. Sarvesh Singh Baghel, learned counsel appearing for the respondent number 2, State of Uttar Pradesh, has filed a counter affidavit supporting the case of the appellant complainant and stating inter alia that the High Court did not consider the fact that the present case involves a serious offence. There are accounts of eyewitnesses that have categorically specified the role of the accused respondents and that there was a definite motive to commit the offence and injuries were caused intentionally that had resulted in the death of the two deceased persons. It was further submitted that there is a likelihood of the accused persons influencing the trial and threatening the eyewitnesses. We have heard learned counsels for the parties carefully examined the records and the impugned orders. The short question that falls for our consideration is whether the High Court was justified in exercising jurisdiction under Section 439(1) of the CRPC for granting regular bail in favor of the respondents in the facts and circumstances of the present case. As noted above, this is the third time that the appellant complainant has approached this court for relief. Earlier hereto, aggrieved by the order dated 4th of August 2022, passed by the learned single judge of High Court of Judicature at Allahabad, directing release of Niaz Ahmed, father of the accused Waseem, in connection with the very same case, the appellant complainant had filed an appeal. Noting that successive orders were being passed by the same judge of the High Court mentioning identical reasons as stated in the order dated 4th August 2022, this court had expressed its dissatisfaction and opined that merely setting down legal formulations cannot be a ground for granting bail and that due application of mind was not apparent in the facts of the case that reveals the seriousness and gravity of the offence. As a result, the order dated 14th August 2022 enlarging Niaz Ahmed on bail was set aside and the appeal preferred by the appellant complainant was allowed. The second round of litigation took place when the appellant complainant approached this court, being aggrieved by an order dated 22nd August 2022, passed by learned single judge of the High Court, admitting the accused Waseem to bail in the same case. Since bail was granted in favor of the accused Waseem on parity with his father Niaz Ahmed, and the said order was subsequently set aside by this court on 30th September 2022, the appeal preferred by the appellant complainant was allowed and the application for bail filed by the accused Waseem was restored to be decided afresh by the High Court. Stop.